I'll start the recording now. Welcome to another iteration of LunchGPT. I think we're going to have folks joining as we go, but we can go ahead and hit the ground running. Um, we are fortunate to be joined by Kristie at Berkeley, where it is not LunchGPT, but I guess breakfast or Brekkie GPT. We've got Michael up at NYU, and I'm coming from you all live in Miami, Florida. So thanks for joining. We keep these fairly informal. So if you ever want to jump in, intercede, go for it. We're going to go around the horn with the professors here to lend their respective 2 cents. I'll try to just lend my 1 cent. Usually their takes are better than mine. But with that in mind, I'll go ahead and start. And today I'm going to talk about briefly this idea of the abundance agenda. So, for folks who haven't heard of the abundance agenda, that's okay. It's not exactly the most popular thing that's been written about yet. But if you've ever heard of the name Ezra Klein or Derek Thompson, they are releasing a book very soon on the abundance agenda. And I think all of you will find it very interesting. And it's actually quite applicable to artificial intelligence. So the general theory of abundance is that a lot of our problems can be boiled down to the fact that we have a lack of supply. There's just a lack of stuff. And this came really to the fore during the COVID pandemic, where we realized we didn't have enough masks, we didn't have good public infrastructure, we didn't have affordable housing, we didn't have a sufficient supply of doctors, of nurses. And what Ezra and Derek dive into, or will dive into, if you're able to purchase the book when it comes out, is really exploring how oftentimes unintended consequences prevent having a more robust supply of the things we need to experience what a lot of people would define as a good society, right? Lower cost to healthcare, ready access to affordable housing. Well, if you look at some environmental regulations, for example, you all being part of the lawyerly profession, knowing things like having bar associations or restrictions on the unauthorized practice of law, all of those things are very well intentioned but can oftentimes undermine getting to the net positive outcome because what happens is we have procedural hurdles often frustrate realizing substantive ends. So that's a long way of saying that this abundance agenda and thinking about how we can create a greater infrastructure with respect to AI is something that I'm very excited about and very passionate about. If we look back historically at different waves of technology, we see that one of the things that has been slow with respect to new and important sources of technology is this question of diffusion, right? So when we had electrification, for example, one of the first things that happened was it was available where there was a lot of wealthy folks, where there was a concentration of wealthy individuals or corporations, and they were the ones who benefited from electricity. It took decades for rural electrification to become a thing. And arguably, rural electrification only occurred because of the Great Depression and President Roosevelt saying, hey, I'm going to feed two birds with one scone. I'm going to create the Rural Electrification Administration and give people jobs and expand access to electricity. So, one of the things I want to highlight and talk about is that we need a sort of abundance agenda for artificial intelligence. If you look right now about who uses AI, you'll see that AI adoption isn't that widespread, right? You'll talk to your friends, you'll talk to, in particular, your parents, you'll look at workforce data, and you'll see that AI adoption rates are very disparate across the country. And this is unsurprising, right? Because we see different rates of digital literacy, we see different rates of access to affordable internet, and we see that the core ingredients for developing AI, when we think about data, when we think about compute, when we think about AI talent, all of those tend to be concentrated where we already see high wealth, high inequality. And so making sure that all of Americans benefit from AI and not just the folks on the coast is going to be a really big challenge. And having an abundance agenda mentality to this challenge is really important because what it means to ensure that folks across the country can access AI really boils down to, do we have things like transmission lines so that there is enough energy to power data centers around the country? Do we have affordable renewable energy to power those resources as well? Are we building out the last mile of internet access to communities across the country so that they can leverage AI agents and all of the fun possibilities that come about there? So what I think we should all pay attention to is seeing how, to use a phrase my wife always uses at work, we should have a yes and mentality to a lot of goals when it comes to developing AI infrastructure. In the same way that building more renewable energy resources can come about, we should think about how can building out that infrastructure increase the odds of more Americans being able to access AI in their daily lives? And how can we make sure that efforts to improve education, for example, are also building in a component about how we can build in AI literacy? So that's my high pitch to you all is number one, read Abundance when it comes out. No, I have not been paid by Ezra Klein or Derek Thompson to tout their book. Number two, continue to think of what's being called public AI. So public AI is the idea that we should have public infrastructure upon which researchers, small businesses, academics can make sure they're using AI and developing AI with an interest toward public well-being. So check that out. There's going to be a lot of need for lawyers and smart lawyers who can think through crafting new regulations that at once impose some procedural checks on building out these projects, but don't repeat mistakes of the past where, for example, we just can't build affordable housing, for example, in California. Having lived in San Francisco, having paid San Francisco rents, I know Kristie can talk to Bay Area housing prices. It's not a place to be if you're looking to save on rent. And so this is going to be a big challenge of our era, not only with respect to some of these challenges we've discussed previously, but also in the AI context. So that's the end of my soapbox rant. We'll open it up to anyone who has any questions, comments, but otherwise we can then kick it off to Michael as our next presenter. Has anyone heard of
I,
abundance before I went on a rant?
I'm looking forward to buying the book.
Oh, you're going
Yeah,
to buy the book.
yeah. Can I ask you a question? Like, where does your position, and I think even where Ezra Klein's might sort of dovetail or depart from what's going on at Doge and the idea that we're going to infuse AI within the federal government as sort of part of the efficiency or whatever we're calling whatever Doge is doing, it includes an AI in government component. And then I don't remember the author who wrote is the Code, Code America person. What was her name again?
Jen
Like, so
Palka.
she, yeah, Jen Palka. So she's obviously spoken a lot from a progressive angle, like spoken a lot about some of these topics. And I feel like Ezra Klein is very much aligned with what she's saying there. So where do you stand on those things?
Yeah, so there's the notion of abundance, right? Which I generally describe, it's not a deregulatory agenda, but it's a quote, a lot of folks in the space use the term unblocking, right? So it's getting procedures that are captured by special interest, for example, or producing unintended consequences. It's about removing those processes and being more outcome oriented. So that's abundance on one hand. On the other hand, what you're referring to, David, I think is the conversation between government efficiency, which I think is what Doge claims to be trying to pursue, right? As efficient of a government as possible. What Jen Palka and the state capacity folks are focused on is an effective government. And so those are similar words, obviously, but slightly different. Where I think the overriding priority of Doge, as we've seen so far, is cutting government as much as possible to perhaps allow for more market and private-based solutions. Jen Palka and state capacity people are agnostic as to whether it's the private sector or the public sector, so long as government is overseeing meeting public needs. And so that's the chief difference, right? Where if Jen Palka, for example, saw that private infrastructure was going better with respect to building a bullet train, she might say, hey, that's actually a great approach. Let's champion that. But from a so that's the kind of the state capacity difference there is it's not necessarily government is too big, but it's just how do we make sure government actually has the tools to fulfill public ends. Any other questions, comments? Everyone wants to hear from Michael and the latest in copyright. I get it. I do too. Michael, why don't we go to you for the latest update in the litigation land?
Yeah, this is a much narrower summary than both the one I gave last week on copyrightability and copyright infringement and fair use. Also much narrower than an entire book. But an interesting point nonetheless, and for any of you who've taken copyright, this is one of those topics that you may have covered like in the very last day, and then the professor said this won't be on the exam. So there's a part of the Copyright Act called the DMCA, Digital Millennium Copyright Act. There are two primary components to this. There's Section 512, which is notice and takedown, a topic very near and dear to my heart, but a topic that doesn't really come in with AI so much. The topic that does come in with AI is 17 USC Section 1202 specifically, but this component's really 1201 through 1203. And 1202 is about protecting what is termed CMI or copyright management information. So this is often if you see like a watermark on a picture online somewhere, that's an example of CMI. Any sort of information that identifies this is a work by X artist. So if you see something that's like says Basquiat, now you know it's by Basquiat, or you see something that says Kevin, you know it's Kevin. And this has been a claim that often is brought in copyright and copyright-esque cases. It typically is not the most successful because there are two components. So under a standard CMI claim, Section 1202, 1202B specifically, this is if you're removing or altering the CMI in some sort of way. So removing it, you're just getting rid of it. Changing it, it no longer says Kevin, now it says David. And with that, any sort of changes that have happened to the CMI usually go along with a pure copyright infringement claim. You have copied my work. Now you have copied my work, but in addition, you have also removed the CMI. These claims tend to not be very successful because they have a requirement of knowledge. So it's not just that you removed the CMI, it's that you removed the CMI and knew or should have known that this would induce or facilitate infringement. And that has been really tricky under the various circuits that have had to address this. And most of these claims will fail under this knowledge prong. But interestingly, we've also had these 1202B claims brought in the AI context. So many of these cases, and I think I mentioned last week, there are 39 of them right now pending around the country. Most of them are like kitchen sink complaints. A few of them have been very discreet and they're just alleging copyright infringement. Others are alleging copyright infringement, trademark infringement, false advertising, CMI 1202 claims, 1201 claims, which we can talk about in future weeks, basically everything. And most of these other non-copyright claims are failing with a few limited exceptions. And 1202 is one that's had the eye of commentators for a little bit now. And there was a decision a few months ago involving Raw Story, which is a news media org that was suing OpenAI for supposedly ingesting its works. And in the ingestion process, it was alleged in the complaint that they were also removing the CMI. And in that case, in SDNY, Judge McMahon, who was previously the chief judge for SDNY, said that there wasn't standing. So for any of you who have had to read TransUnion v. Ramirez, that was a case a few years ago from this where the Supreme Court said you can only have Article 3 standing if you have a concrete harm. And those concrete harms were tied to historical claims. So there's some sort of historical analog that you can kind of point to and say, this is very similar to historically what we've allowed people to recover for. we're going to allow this newer claim. In TransUnion, it was involving privacy. And TransUnion has now been expanded to a variety of other fields where courts try to apply it, and with mixed degrees of success. And raw story, Judge McMahon said this CMI 1202 claim did not lead to Article 3 standing because there were no allegations. Even if the CMI was removed, there wasn't an allegation that the information was ever reproduced. So yes, it's ingested in the training process, but on the output side, there were no allegations that there were outputs that contained the supposedly infringing work and just had removed the CMI. So because of that, no standing, and Judge McMahon hinted very, very strongly this really should just be a copyright infringement claim, which for some reason was not alleged in the Raw Story case. And she dismissed it without prejudice, so they could have refiled and brought the copyright infringement claim, but no standing for 1202B. Then, around that same time, we get a simply written decision that didn't give the full reasoning from Judge Rakoff, also an SDNY, saying that he would allow a 1202B claim. We finally got that written decision last week, hence why it's timely, and he takes the opposite approach to Judge McMahon, interestingly not citing Judge McMahon's decision at all. So there are now rival opinions about whether there should be standing for a 1202B CMI claim. Judge McMahon says no, there's no historical analog. Judge Rakoff says there is a historical analog. This is basically just copyright infringement. And once you're past the standing hurdle, then he tries to work through the 1202B1 claim here and says that under the allegations, ChatGPT supposedly removed the CMI when ingesting. So we get the removal of the CMI. And then knowledge, which is usually this big stumbling block, he has two arguments for. So the first is that some users might not have wanted to use generative AI if they saw outputs that contained CMI. They would be scared off by the prospect of copyright infringement. Seems a bit dubious as far as a claim, but nonetheless, it was raised. The more convincing, but also potentially more troubling argument is that because OpenAI has indemnified any sort of chat GPT users for any infringements that might occur, that shows that they might have knowledge that infringements will occur. And therefore, there is that knowledge that CMI violations could lead to infringement. And again, this might be a little bit of a stretch as well, but it is a bit worrying because a lot of these major companies in the AI space have been indemnifying users for infringements. Not necessarily because they think infringements will occur, or if they think they occur, they're all that likely, but rather as kind of a best practice of this is an unknown space, we're in uncharted waters, we don't know yet, and better to help our users out rather than have them be on the hook. And so the final point here, just with damages, copyright infringement usually can range anywhere from $200,000 up to $150,000 per infringement. 1202B claims, these can go anywhere from $2,500 to $25,000 per violation. So because there are so many works that are ingested in the training, if a 1202B claim would succeed, this potentially could lead to a lot of liability for these online platforms or up the ante in potential settlement negotiations. Again, these are all motions to dismiss, so it's not the hardest standard to get through, but this is nonetheless an exciting update on something that's a bit more substantive than where we were at, which is pure copyright claims at the motion to dismiss stage. So I'll leave it there for any questions or discussion that might be helpful.
Any questions for Michael? Okay, I'm just going to say it again. I know I'm a broken record, but lots of fodder for your next note, right? You all are welcome to take anything that's said here, use it for that next note, that next blog post, and feel free to reach out to any of us.
I'll echo that. There's really not much that's written on 1201 through 1203, so it's a good area to write on. It's also quite complex and not the best written, so it's a good area for potential employers too. They'll be happy that you know something about a very complex area of law.
Wow, there we go. Well, you heard it here. We're giving you not only AI in the law, but AI and employment and the law. So it's all happening. Thanks, Michael. And let's go to David in Kansas next.
Hi, everybody. Thanks for organizing this, and I'm really happy to be with you all. I wanted to talk about some of well, I just said backlash, but I meant to say whiplash between the Biden administration and the Trump administration's approach to AI regulation, and with a little bit of a focus on AI safety concerns. Let me start with the Biden administration. In late 2023, as I'm sure you all know, as concerns about frontier models and generative AI were really coming into sharper view, the Biden administration issued Executive Order 14110, titled The Safe, Secure, Trustworthy Development and Use of Artificial Intelligence. And really, it was at the time, and still, the government's most comprehensive approach to governing AI, and it mostly was directed internally. It was mostly directed at federal agencies. But some of what it was directed at was making sure that federal agencies were looking into how it might better safeguard the public and consumers, so some regulation, and also some issues of safety. But basically, it created directives for more than 50 agencies. There were a list of more than 100 to-dos that were issued, and it covered a range of sort of themes and topics, as I mentioned, from safety and security to civil rights and bias, to consumer protection and privacy. And as I mentioned, the federal government as being a user of the technology, and what the federal government could do to make sure that it was using the technology safely and responsibly. And it also called for international collaboration. For example, the order says that the United States should be a global leader in AI governance. And so I just want to emphasize that. It will segue into what I'll be talking about next, right? Not just a leader in AI technology, which I think America is the undisputed leader in AI technology, but also a leader on the global stage in AI governance, which is, let's just say, a loose term for policy and regulation. So the executive order is approached all of these issues aligned with what was recently the Hiroshi AI process, which was also, I believe it was in the summer or early fall of 2023, with the ideas that countries would come together and focus on coordination and perhaps coming to some agreements about some of the geopolitics and common concerns on an international scale. So following the 2024 election, the incoming Trump-Vance administration wasted very little time in reversing course. On the very first day Trump was back in office, Trump issued an executive order which repealed Biden's executive order 14110, and then later that week issued a second executive order titled Removing Barriers to American Leadership in Artificial Intelligence. So I'll just sort of, it's actually very light on details. One of the trivia points, is that Biden's executive order clocked in at more than 100 pages. It was reportedly the longest executive order in history, on any subject, and with just literally the stroke of a pen, was just repealed on Inauguration Day. And then a few days later, I guess we have a temporary, not so much a replacement, so much as a placeholder, but it was very short on details. But I could tell you sort of what the vibes and some of the messaging in the follow-up executive order. In addition to the revocation of 14110, Trump's executive order called for a review of this, anything that the Biden administration had done. And so, as I mentioned, many agencies were in the process of looking into how to perhaps regulate or oversee the use and development of AI in the private sector and the commercial market. All of those were on hold. Some of them have already been rescinded. I mean, one of the just to get a sense of how slash and burn this is, like, even guidance documents from agencies that were not binding on the industry, even those are being repealed. So it's not as if, and by the way, I think it's very important to point out, for everything, and for the size of the executive order, there was no binding there was no binding regulations, except a few things about reporting, and there was some international trade restrictions. But in terms of like your domestic regulation, consumer protection, privacy, safety, all of those things, there was nothing in the executive order itself, much less from any of the executive agencies that were binding on industry. But I guess even just the threat that those things might be coming in the future was enough for the Trump administration to basically rescind, or to at least put on pause. And there's no expectation that those are going to go further under the Trump administration. Instead, we're waiting for a new AI action plan. And again, we don't know the details of what that will be, but we do know just in general that it's going to be very innovation focused, accelerationist. What can the government do to support research and innovation? What can the government do, like as the title of the Trump EO suggests, how does the government remove barriers to American leadership, not in AI governance, but to remove barriers to AI leadership in AI developments, right, and dissemination. A couple other things worth pointing out. The tone of the Trump administration's executive order also, and some of the language talks about promoting free markets and avoiding ideological bias in AI systems, right? So the idea that, and this I think is a quote, the US must develop AI systems that are free from ideological bias or engineered social agendas. So of course, this aligns with talking points that I'm sure you're all generally familiar with, throughout the election cycle, but then even certainly within the first month of the Trump administration, about rooting out quote unquote woke AI and DEI initiatives. So all of that is sort of been now tethered. It's been hinged, all of these, I'll call them culture wars, to AI governance, which is actually my next article that I'm really going to be focused on. I won't get into sort of the culture wars in AI governance, but I actually think it's something, well, I'm certainly interested in, and looking forward to doing some more research and sharing my findings on that. But just if you think about, how culture wars just very quickly can lead to stalemates, can lead to vitriol. And if you worry that AI is maybe too important to relegate to the culture wars, well, that ain't happening. And so I think it's important to think about not just what the culture wars express in terms of their rhetoric, but how the culture wars are going to affect policy formation at all levels of government, including at the state level. And that's where my academic research has been focused on. So the executive order from the Trump administration, it kind of gets crystallized, or is sort of on an international stage. It gets amplified when Vice President Vance attends the AI Action Summit in Paris in February, earlier this month, and these sort of these used to be called like AI safety summits, and it's like even the title is not even really referring to AI safety anymore. But this is the first major policy address abroad, and Vance is appearing on behalf of the United States government. And sending a very, very different message than certainly the Biden Harris administration. And so some of the choice quotes, some of the headlining quotes, he begins by saying, I'm not here to talk this morning about AI safety. I'm here to talk about AI opportunity. So this is just right from the outset, just a reframing of what had, in the prior 2 years, really been a focus, for better or worse. I mean, there are so many things to focus on AI, but these conferences in particular were focused on things like catastrophic risk, the major harms that could be caused by rogue users of AI, or maybe some hypothetical future, super intelligence, but really focused on AI safety. And this conference really turned into, with Vance really leading the charge, into much more of a foot on the pedal, foot on the gas pedal for AI acceleration. He says the future of AI will not be won by hand wringing about safety. It will be won by building. And so not just AI, but the infrastructure, the energy requirements to promote the sort of frontier AI systems. He says that I believe that AI will facilitate and make people more productive. It's not going to replace human beings. It will never replace human beings. Of course, there's no citations for any of this. But it's, again, it's not so much the truth of the matter asserted so much as the shift in emphasis. And I don't know, maybe AI won't replace jobs or disrupt the job market. But certainly it seems that this administration doesn't really have a plan, or is not even concerned if that's the case, because it's not only not focusing on AI safety and let's say job display, it's not even on the agenda. It's sort of anti-agenda to even be worried about catastrophic risk, even worry about the displacement of the labor market, or the disruption of the labor market. And then he also says things like, we feel strongly that AI must remain free from ideological bias, and American AI will not be co-opted into a tool for authoritarian censorship. He also bluntly warned European regulators, so this is, I think, important too. I mean, really throwing down the gauntlet and driving a wedge between, or potentially driving a wedge between, the US approach and what had been thought to be an important ally, certainly in the geopolitics of AI governance vis-a-vis China. But it now seems like we might even have a wedge between the US and the EU, because again, it's not only that the Trump administration is pushing the pedal on AI innovation, AI development, it's also really calling out and not, I wouldn't say threatening, but it's really drawing a line in the sand and say, hey, EU, you're free to join us, the American approach, but we're not going to tolerate the EU regulating our American companies. I mean, those intonations are clearly part of the messaging from Vance at the AI summit in Paris. And so it's again, without any commentary. I've actually tried to avoid others than just the work thing, because I think it's worth pointing out that we don't know what the impact on jobs are going to be. And I think it's telling that just to say there aren't going to be any, it means that, well, what if there is a displacement? What work is being done on those things? What work is being done on AI safety? I mean, even if it's a remote chance of really catastrophic risk, it seems like they're saying it's not even a danger, and they seem very concerned about wokeness and DEI stuff, and really downplaying some of the other issues that we as a society are confronting. So that's my report.
All right. Well, thank you for the Paris debrief. It's going to be very interesting to see how the international race proceeds from this point forward. In case folks haven't seen subsequent announcements, it looks like the EU is doubling down on AI infrastructure, public AI infrastructure. A lot of countries there trying to pool funds together to help compete against the US and China. We'll see how that race plays out. Any questions for David? Any general comments? Another good note area. I know I'm going to stop, but really, any comments on this, the international dynamics, and in particular, what folks are characterizing as a swing from AI safety to AI security is a really interesting point right now. And we'll see if the pendulum swings back at some point. So far, we've seen that folks don't necessarily have a clear North Star about what their policies are going to be, but seem pretty susceptible to shifting political winds. So let's go to Kristie, certainly not least, but yes, last. Kristie, what are you going to share with us from Berkeley?
Well, I am excited to share. I'm going to do another book review. So I am going to talk about, it's a really new book. I think it's just a couple months. I remember being very excited when it came to my mailbox. So Super Agency, What Could Possibly Go Right with AI by Reid Hoffman and Greg Beato. I put a couple links in to the chat. One is to the book, and then the other is to a podcast that I have to admit I hadn't been focusing on until I read this book. I don't know if anyone has listened to the Possible podcast. It's Reid Hoffman, along with Aria Finger, who is Michael is also at NYU, an adjunct professor there, and works with Reid Hoffman. That cover a range of topics. Of course, they've been doing a lot on this book lately, I think, to kind of get it in people's minds. But it's a great podcast just on looking at some overviews and generative AI more generally. So I think it's worth taking a look at. So, but what I thought I would do today is give a quick, my take on this book. I do recommend it, and a couple takeaways and things to think about for you as all the law students joining us. And before I do, just quickly for those who weren't here last time, I am, as Kevin said, over at UC Berkeley. I'm the instructional and educational tech librarian, which means that I focus on all things thinking about how is legal tech affecting us in law schools and in legal practice. And before coming here, I was in legal practice for a long time as a litigator and a senior staff attorney at the California Court of Appeal. And I just have always been fascinated by how technology can amplify what we do as attorneys. And I think that some of the ideas in this book really go hand in hand with that outlook. It is definitely, I will at the outset say, this is an optimistic take that, as you probably see from the title, and some of the things we're talking about, regulation, legal issues. There's a lot to think about, but I think this gives a really good framework. But quickly, just about the authors. So Reid Hoffman, you may have heard of him as the co-founder of LinkedIn. He's a longtime tech investor and AI advocate. And he seems to be, I hate to lump tech folks all together in one bucket. He's not as controversial as some out there right now, I think. He seems to take a pretty balanced approach. And he authored this with Greg Beato, a journalist who brings some historical, cultural perspectives to the AI discussion. So they're both pragmatic, optimistic AI folks. So a couple of the key concepts from super agency. So they look at how we should be thinking about where we are. They categorize 4 types of AI users: the doomers, the gloomers, the zoomers, and the bloomers. I wonder if they used ChatGPT. I was so excited to have those rhymes. But anyway, I mean, the how they define these terms aren't surprising, but I think it's a good way to think about it. And big reveal, they are bloomers, a balanced approach. But the doomers, we've been all reading and a lot about, folks who do feel very strongly that AI poses an existential threat, that it could surpass human control, take over critical systems, and really want regulation or a pause, those sorts of things, or I should say heavy regulation. And the gloomers, not quite as pessimistic as the doomers, but are actively, advocating for more top-down regulation, all of the concerns that we should all be thinking about, bias, and, environmental, taking away decision-making, all those kinds of things, misinformation. Zoomers, on the other side of this spectrum, they are just, let's full steam ahead, no room for regulation, we'll figure it out. The benefits just so far outweigh the risks. We can't slow down. We've also probably all been reading a lot about, concerns with global competition, where we're going to be, and just what all the issues that David and Michael are talking about. But and then the bloomers. So this is the more balanced approach to AI, starting with skepticism. But really, and the take in this book is that there are so many benefits, and it's interesting, and I'd be curious what other folks think. Maybe we can circle back to it. But in terms of regulation, they are very in the camp that we should be taking an iterative approach to deploying these general purpose systems, right? And they talk a lot about, part of the title of super is that this is a technology that we can all be using. And I think I agree with that. And for law students, that we should be actively engaging with it, thinking about how to use it. But this iterative approach that companies should be allowed to release, like ChatGPT did, without too much regulation, these systems, and then let them evolve with lighter regulation. So it's an interesting read in terms of how to think about how we'll be approaching regulation. But a couple takeaways, just, that one of the big overarching concepts is that, the concept of the technosapien, and we all use technology as an extension of ourselves, like writing, printing press, the internet. And this is just this next step that can really increase our agency in the world. And some of the things I thought that were interesting. I mean, I think with a lot of people have been saying this, right? This can really amplify what we do. We can use it as a collaborator, a partner. But I think that one interesting thing that struck me is that, talking about how they talk about how it can increase your own agency, let's say, as a learner, as an attorney in appropriate ways, but that how this term super agency, as it will allow others to become more effective, that is a benefit to society as a whole. They give examples from other technologies, things like when the automobile was invented, right? That would allow doctors to come to, not just the elite. That it's an interesting thinking about agency of others and how that will benefit and your own sort of extension of what you will be doing and how to use it. And again, this notion of iterative deployment, that this is a tool that becomes the most powerful when users, actively engage and experiment, and this iteration in terms of prompts and being able to work with these again as more of a collaborator makes it very different from other tools we've had. And I think another important point that they make is that, I've been talking to students a lot about, really that you have to understand the different types of AI, right? And understand that AI has been around for a long time. And that really the way they frame the difference now is this notion of, for so long, AI has been working on you rather than by you. So I do think it's an interesting way to think about when you think about things like predictive AI, whether it's something pretty innocuous, like, you're using Netflix and predictive AI is letting you choose your next show. That's great. You're not choosing to use it oftentimes. And the not so great ways where, predictive AI decides you don't qualify for a mortgage. That's AI being used on you, reducing your agency, right? And I think in the last talk, I mentioned another book that I recommend, AI Snake Oil, that's really good, that really talks about the differences with predictive AI, right, versus generative AI. And, this seems sort of simplistic, but I think the authors talk here about, here with these types of tools that we're thinking about, individuals have the power to use AI for themselves, expanding their own agency and control in lots of different ways. And I don't want to there's so many examples I want to give with this, but one of the examples that resonated with me in terms of, okay, that sounds great. What are some of the big ways that we think this can give us more agency? And I really think this, they talk about big data to big knowledge. I mean, this notion that we are, buried with an avalanche of information, and that people can use AI to filter and amplify and apply knowledge in new ways. I think that is just a framework that is I think a powerful way to think about using AI is how we can, humans, they give some good stats about, how information has just increased exponentially, but we can only as humans process so many words in our brains, and really be able to hone in and reduce barriers to expertise, and enable personal learning and growth. So that's really where the a lot of the positive outlooks come through. And for for law students, I mean, this book does not, it doesn't focus, has some good examples about the law, doesn't really focus on it. It talks about some interesting things about AI and the future of contracts, how AI might be incorporated into contracts in the future where, let's say you have an agricultural agreement, there's AI that's working to be able to make these contracts fair, that's taking into account weather and different sorts of things, all kinds of problems with that, right? Like the black box and how that would actually work. But I do think it's still really worth a read, because I keep saying over and over, there's so many tools that are being thrown at you, and just really getting an understanding of some of the, you know, helpful use cases where it's not working so well. And I do think it, I was saying I'm a big fan of Ethan Mollick. It kind of is in that same vein of things we, you know, we sort of know, okay, we should be engaging with this, we should be learning about it. But I think it does really explain it in a way that resonates and gives a good framework for thinking about some of the more positive aspects of how AI might be used. So that's my review. I give it a thumbs up.
All right, a thumbs up. We'll have to come up with a new scale, the Kristie scale. Maybe 2 thumbs up is the highest mark there. Excellent. Well, we've got about 15 minutes left. We've covered quite a lot, from book reviews to great international analysis to copyright. So open it up to you all to talk about any of those topics or anything else that's top of mind for you. And this is not class. No one's going to cold call you. This is all voluntary. So feel free to just speak out.
I have a quick question.
Shoot.
So, following the Reuters and Ross case, it seemed like a lot of discussion online by like legal analysts, and so keep bringing up how the fact that it's not generative AI is going to have significant implications on its use for future cases. I'm just curious if you could talk through a bit more of what types of cases this would have implication on in the AI space that aren't generative AI companies. It seems like all AI companies these days are trying to be generative AI companies. I'm just curious what the exact utility of this is in the future.
Yeah, so with the Ross case that happened 2 weeks ago now, the decision there in the District of Delaware by Judge Bibas, who usually is Third Circuit, but was sitting by designation. Um, it was a pretty short fair use decision. I think somewhat surprised folks because it was this case that a lot of people were watching. The thing to really keep in mind there is competition. So under the 4-factor fair use test, theoretically, it's non-exclusive, and in practice, it's really just those 4. Courts are really going to care about the first and the fourth factor. So the first, is the purpose the same? Fourth, is there competition? Are you usurping some sort of existing market or market that could emerge? And those two obviously are very related. And even the Supreme Court in the Warhol decision, which tried to just take the first factor, failed to actually do that and kept mentioning the fourth factor, sometimes implicitly, but it's mentioned. With Thomson Reuters v. Ross, both the Thomson Reuters head notes and the Ross product were both search engines for legal research. So there, the purpose was very similar. And competition, of course, like you're creating a product that's going to compete with Thomson Reuters Westlaw that we all know and maybe love. Some people might be more pro Lexis, that's fine. Although my students know I am not. So that's, I think, the big aspect of where it's kind of limited. And because you have these two competing products compared to ingesting a book. So, you know, like the books that Kristie was talking about, if those are ingested into the training set, now ChatGPT is making some sort of new book or response or something else. It's likely not going to be that copy. It's probably not going to compete with AI Snake Oil or the Super Agency book or anything else. It's possible they might reproduce similar facts or ideas, but the facts or ideas are not copyrightable. So I think that gives some commentators more hope that the AI fair use cases right now might not come out the same way as Thomson Reuters v. Ross. They still could, but I think it's going to be a tougher call compared to Thomson Reuters v. Ross, which at least to me always felt a little bit risky. And we'll see. I mean, I think it's likely that Thomson Reuters might be appealed to the Third Circuit, and then we can see what happens there too. But the facts are just, they're different because of that competition and the purpose side in a way that we've not seen that so far. Although there are some complaints that might be a bit better, like the New York Times one, for example, where there are outputs that are verbatim copies of New York Times articles. Open question of how much work it will take to get those copies, but that's maybe a bit closer than just, oh, you copied my book as one of the billions of pieces of data that you copied.
And I think David's got a answer to a question for us next. Thanks, Anu, and thanks, Michael.
Yeah, so I received a question sort of directly through the chat. I won't use the person's name because it wasn't to everybody in case that person didn't want their name revealed. It was an excellent question. And it asked whether I thought that the lack of safety concerns from the current administration, the Trump-Vance administration, may cause some action from Congress on the issue of AI safety. And again, who knows? Let me first say, this actually was, I did respond directly to this person, but let me say one thing I did not put on my response, and I should have, which is one of the things it will depend on, like if there is some kind of a catastrophic event or some kind of, let's say, AI it gets into infrastructure, either from a malicious actor or from some negligence or for whatever reason, something that might prompt sort of public outcry for some sort of government response. That if that happens, then sure, you might see a shift out of Congress. But I would say if we see more of the sort of the status quo, where there are anxiety might run high, but we don't have an actual event, we're not going to see anything. It just might sense. It just, based on everything I know, and I watch this very closely, we're not going to see any kind of serious, meaningful regulation out of Congress. Perhaps you might see something directed at the federal government's use of AI, but you won't see, in my estimation, and I feel very confident about this, barring, again, some sort of a major event, anything from Congress that is going to impose any kind of direct regulations on industry regarding AI safety, catastrophic risk, anything like that. We might see things like deep fakes, around the margins, but those tend to be directed at the users of AI. It's like very downstream. But the AI safety type regulations, to the extent that those would be focused more at the model level or at the juggernauts that are making those models, there's just, not only is just there's no appetite for that, but you can imagine very significant lobbying to prevent any kind of regulation from Congress in that sense. And then, of course, I would also want to cite that the Republicans party platform leading up to the election really was not very long, but one of the things that they took on as part of the platform was to repeal Biden's executive order, and everything that entails. So it's very much part of the Republican platform. And of course, they control both chambers, at least for the next 2 years. They have no interest in regulating AI in the private market. And then I would also point you to the December 2024 bipartisan House AI task report, which is, 300 pages long or something like that. It's an excellent document. It's got tons of resources. But again, the emphasis is just not on any kind of serious regulation on industry, much less on issues of catastrophic risk or AI safety writ large.
All right. Yes, the safety question. Let's see here. From Ethan. Is a person who creates the prompt a company? Michael, I think this is for you. A person who creates the prompt or the company, either an image or published written work, not able to be held liable for something a generative AI creates?
Yeah, so this is a great question. It is something that I have an article right now for any of you on Law Review. It is still available on this very complicated question of if there's an infringing output. So most of the fair use questions we've been talking about is the training of an AI system in copyright infringement? And that's where the attention of those 39 cases is largely directed. But there's also the question of when there's an infringing output, what happens there? So whether it's an image, a book, a piece of writing, whatever it might be. And most of the computer science literature and a few legal scholars have shown that there will be infringing outputs. How often they occur, it's probably a few dozen out of a few thousand hits, maybe even less than that. So it's unlikely, but still, due to the copyright damages being very high, up to $150,000, it's a big question. And it's something that people are trying to grapple with. It feels intuitively wrong to put the onus on either the generative AI provider being always liable for any infringements that occur. Generally, copyright law says if you have new technologies that provide both infringing and substantially non-infringing uses, you wouldn't be held liable for those. And that's the language in what's termed secondary liability, which some of you might have heard about in torts. But there's kind of a similar approach in the direct liability context. We want the one who actually caused the infringement to occur to be the one held liable because they could deter it and foresee that there might be an issue. It also feels wrong to put that on the user and say, oh, you put in a prompt, you didn't know what was going to happen, it spat out an infringement, you're now on the hook for $150,000. Certainly some platforms are trying to, or some AI providers are trying to block that possibility by indemnifying them, as I mentioned with the earlier intercept case. But both seem somewhat normatively unattractive. We don't really want to say like all or nothing, but copyright is a strict liability claim, which means it is an all or nothing situation. So in that article that I mentioned, I'm trying to kind of argue for more of a secondary liability approach, where we try to shift the whole conversation to the provider or user being held secondarily liable and kind of engaging with the sort of legal fiction where the AI system is the direct infringer, just so we can get to that secondary liability point, which considers intent. So if you're kind of playing around with ChatGPT and you're specifically trying to get to regurgitate the first chapter of Harry Potter and the Half-Blood Prince, you should maybe be on the hook for that. You were doing something bad, knowing that it would likely lead to infringement, and you could have done something differently. Similarly, if there's a provider of a system and they're aware of an infringement problem, such as these are common examples, typing in any sort of prompts that ask for a cartoon Italian plumber that will always lead to a Mario-esque figure, then the provider should do something to the model or to the system to prevent that from occurring in the same sort of way, whether that's changing the model itself or adding some sort of filtering mechanism or blocking types of prompts. There are different possibilities, but at least thinking about intent, I think, is the right spot. And there are some other scholars who have been thinking about trying to change copyright infringement entirely and shifting to more of a negligence-based standard than strict liability standard. I personally am a bit more in favor of the secondary liability approach because it doesn't change all of copyright, which there are good reasons for why we've had it the way we've have. But that all to be said, you hit on a very good question that courts will probably not answer for a few more years still because they're still caught up on the training side.
All right, folks. Thank you so much for joining. I think we'll leave it there. This was a wonderful conversation. I'm going to put 2 links in the chat. The first is the student interest form. Please, please, please share it with your friends. They're going to be so jealous they didn't get to be a part of this conversation. We are going to post this video, so maybe they won't have too much FOMO, but please do share it. And then I've also posted a link to a Substack where I try to share some of these resources on a more regular basis. Long story short, thanks for being here. We hope to see more of you. We'll plan to do this again soon, and we'll be sure to spread the word once that happens. So have a great week ahead and go use AI responsibly. And we'll talk to you all soon.
Thanks. Bye all. Good to see you.